This is Contractor Sense with Ruth King.
Welcome to Contractor Sense. Here you discover ideas, tactics, news, and information that matters to your contracting business and you. I'm your host, Ruth King. This episode is sponsored by Profitability Movement. Google Profitability-Movement to join this community of business owners focused on building profit, increasing wealth, and giving back. Thank you for joining us. Here is how we will help your business and you today. How do you make sure you're covered when you sign a contract? What about pay-on-pay clauses or lien rights? My guest today, Karalynn Cromeens, owner and managing partner of the Cromeens Law Firm, gives you the answers to these questions and more. Karalynn, welcome to Contractor Sense.
Thank you so much for having me, Ruth. I'm excited to be here.
Oh, my pleasure. So you've been a lawyer and you've been dealing with construction law for a really long time, right?
Yes, for like 17 years. Goes by entirely too fast, if you ask me. But,
Yeah. And so I'm sure you've seen the good, the bad, the ugly, the stupid and the dumb, and the smart.
You know that the construction industry, as a general rule, is a rough and tumble business. And the downside with being a lawyer in construction law, I never see a good project, right?
Yeah.
But if I'm involved, something went wrong.
Yeah. Unfortunately, quite frankly, there are really good projects out there that go really smoothly and everybody makes money and everybody's a happy camper. But you're right. You only see the stuff that doesn't go right.
Yeah. And I try to get on the front end to help that those projects go smoothly. So less of them end up on, with me getting involved on the back end.
Yeah. And you've written a book to that effect, right?
Correct. Quit Getting Screwed, which is all about the bad stuff that's in commercial subcontracts. If you're signing somebody else's contract on a commercial project, as far as a subcontractor, there's lots of bad stuff in there that people don't realize the effects of what could happen.
And where do they get the book?
At Amazon.
Okay.
It's Amazonable.
Very good. So, if you want to protect yourself before you start, go read Don't Get Screwed. Yep.
And also, because I'm so passionate about it, I teach the 20 chapters in that book for free on my platform, subcontractorinstitute.com. It's because I want people to have the information and to know what it means.
Yeah. Well, the thing is that, if they've done the right things up front, your job becomes easier.
Yeah. Well, hopefully I won't have, my job is helping them on the front end so they won't see me on the back end, right?
Well, no, sometimes they're going to see you on the back end anyway because somebody doesn't pay or something along those lines. And if all the stuff and the I's have been dotted and the T's have been crossed before the project started, the back end makes your job easier.
Absolutely. Absolutely.
Yeah. So, all right, let's talk about some of the things that they should be careful of when they are signing a subcontract.
So, yeah, the first thing that I would be wary of is like you said, the pay when paid clause. And what that means is that you as a subcontractor won't get paid until the owner pays the general contractor, which is something you have no control over. So, right. That means that you could do a perfectly good job, have everything finished on time, but something goes south between the owner and the general that has nothing to do with you, and you still don't get paid. And so what that means is when you sign a subcontract, 100% of the risk of non-payment is shifted to the sub, right? And so basically you should have enough cash on hand to do the entire project without getting paid, because there's a pay when paid clause. Even though you haven't been paid, you still have to keep working. Right.
Well, yeah, and you still have to pay your suppliers and your employees and all that sort of fun stuff. Is there any way to get out of the pay-on-pay clauses?
So there is, like, if you can, I have in, Quit Getting Screwed, there are 3 ways to negotiate them on the front end, like getting paid 50% or filing a lien. The other way, too, that's very effective that can not actually get around them, but if you start the lien filing process, like sending of intent to lien to the owner or to the lender, that if the general contractor really hasn't been paid, that could force payment. Or if he has, you'll be prompted that he has been paid and that you haven't been. You can jump on that issue and make sure you get your lien filed. So those are the most 2 effective ways I've found to get around those types of clauses.
Yeah. I know in Florida for projects that are a certain size and up, but I can't remember what the minimum is, you have what are called NOCs or notice of commencements, which are probably part of the pay on pay, right?
Yeah, absolutely. And so the notice of commencement, and multiple states offer that too, is like to let everybody know this is the project has started. Here's the general, here's the owner, and basically give all the information required to the people that you should give notice to if you haven't been paid. And I know Florida also is one of those states, and all these states are different, that require like a preliminary lien notice. So like within a certain amount of days of starting the job, you got to send a notice to the owner saying, hey, I'm working here. If I'm not paid, I'm going to file a lien, even though you're really not owed anything, past due anything at that point in time. That way, I think the whole thought behind that is to make sure that the owner and the general they don't always know if you have a sub or a material supplier, but if you send those notices, they can make sure before they pay the sub or the GC that everybody's paid, so that liens won't be filed.
Right. And I think in those states, it's smart, but you also have to follow through. If you don't get paid, you have to file the liens. Otherwise, you're out, right?
Absolutely. Absolutely. So that's the thing, is that a lien is a great remedy. It's great leverage, but there are lots of steps to do them right. And they're different in all 50 states. But a lien secures the amount that you're owed for labor and materials, with the property. So basically, it's like the same as a mortgage lien that, if you take out a loan to buy a house, it's filed in the real property records, and it's very, it stays on there until you get paid. And depending on the length, depending on what state, you have to file suit to enforce the lien to keep it alive. But
yeah, and a lot of it is state requirements. Like the requirements in Washington State, I'm sure, are different than the requirements in Florida, which are different than the requirements in Massachusetts. All the way aligned. Is there anything that's consistent for all the states?
That an actual lien has to be recorded in the real property records when you're ready to file a lien, and then some type of notice is required before. When and how you send it is different in all 50 states. I'm working on a project to let every contractor know what their rights are. So Subcontractor Institute has the rules for all 50 states there to file a lien. I'm also interviewing specific construction attorneys from every state and to dive into, just the notices and everything that's required in each different state, and then the practicalities, because the law can say one thing, but what's actually happening could be a little different, or it's interpreted differently. So I really think that you want to improve your cash flow, get a process that enforces your lien rights, and do it consistently.
Yeah, absolutely. Before we take a break, give everybody the name of your book again.
Sure. It's Quit Getting Screwed, and you can get on Amazon.
Sounds great. We will be right back. Thanks for listening to Contractor Sense.
Do you ever have warranty leak issues? One of Ruth King's clients did about 4 years ago. Thousands of dollars in expense and unhappy customers. She solved this problem for him, though. How? With a leak letter that every customer must sign when a service technician discovers a refrigerant leak. Once they implemented the letter, there were no more warranty leak headaches. No warranty leak callbacks. Happier customers. The surprising result was more replacement sales, too. To get a copy of the leak letter for free, just send Ruth an email at ruthking@hvacchannel.tv. That's ruthking@hvacchannel.tv.
We're back. Thanks for listening to Contractor Sense. I'm talking with Karalynn Cromeens, who has written the book, Don't Get Screwed, and she is the owner and managing partner of Cromeens Law Firm, who is very knowledgeable in how to not get screwed in all 50 states as it relates to construction law. So, Karalynn, tell me one thing that everybody listening to this podcast should do when they, hang up and we're done with the podcast.
Okay. So, in my mind, there's two, like from the legal perspective, there's residential contractors and there's commercial contractors, right? So if you're a commercial contractor, make a plan to have somebody review your contracts before you sign them, so you understand what is in there, like, or Quit Getting Screwed, do that. My residential contractors, and sometimes I think that they shouldn't have a contract. There's no project too small for a contract or terms and conditions. So if you don't have a contract, I do them on a flat fee for all 50 states, or if you just want some keys and pointers as to what should be in your residential contract, I have some great free blog articles at theCromeensLawFirm.com that has, if I was going to write what goes, the terms and conditions that go into my residential contracts that I draft for my contractors.
What about maintenance? I mean, there's a lot of things with respect to maintenance that, really should be in some sort of legal contract, correct?
No, absolutely. And I think the maintenance becomes important when we're talking about warranty, right?
Uh-huh.
So saying that, and this is on the residential side, saying that, I'll honor a warranty claim as long as you kept up with the maintenance required by, the manufacturer.
Right.
Or, like a great example I have is like, if I'm a landscaper and you don't water your plants, that's really kind of a maintenance thing, and I'm not going to warranty that, right? And so having that in the contract, though, is hugely important.
Yeah. I mean, there's, what we call the acts of God that contractors don't cover, but there's sometimes stupid stuff like dogs doing their business on units and then the homeowner wanting to have you responsible for it. We found that out one time, and I'm sure you've got even more crazy stories than that.
No, yeah, I mean, like, so I always put in there, especially from residential guys, if the dogs get out, we're not responsible, because it happens all the time, right? And especially if you're like an exterior painting, if I trample the bushes, I'm not responsible. And another thing too is painters and residential remodelers having a set of standards that they're judged by. So like my painting contractors, the PCA has a great standards. And so if you reference that in your contract, so like in that aspect is like, if you're going to judge somebody's painting, you got to stand so far back away from the wall, and there's, it tells that there's variance in shades and all of that. So that way they can't go over your back with a flashlight and be like, oh, this is inconsistent. You're like, no. This is according to the rules that we've discussed or that are in the contract. This is how we judge our work, right? This is the standard. So I think that's an important thing to reference in your residential contracts.
Yeah.
The commercial guys aren't nearly as lucky, because they basically got to give whatever warranties in their contract. And some big things that they might miss is that their warranty period doesn't actually start until the entire project's over, right? And so that could be, if you're like one of the first guys on the ground in the project, that could be potentially years after you're finished that the warranty still hasn't begun. And then the other thing on that one is there's nothing in those contracts that say you have to be paid in full to honor the warranty. So I try to make sure to put that in both commercial and residential contracts.
Yeah. So let's talk about that for a second. Let's assume you are the first one out and you have to maintain the warranty even if the project is not finished for 3 years, correct?
Yep, absolutely, because that's what the terms of the contract say that you've signed. Because here the whole thought behind that is the contract period to the owner doesn't start until the general contractor turns the project over to them.
So like a certificate of occupancy or something like that.
Right.
Yeah.
When that would actually start. So it's just something to keep in mind when you're negotiating a commercial contract, and, somehow based on what your work is, limit what the warranty might be, or just realize that that's a risk that you're signing when you sign those contracts.
Right. Now, there's something I didn't mention at the beginning when I introduced you, but retainage and payment of retainage is often a contention, because sometimes generals take a year to pay the retainage, sometimes more, and, screaming about it. Is there anything you can put in the contract about retainage?
I mean, yes, you can put it. It's already kind of law in all states that once the general contractor gets paid retainage, he's supposed to pay the subs. The problem is that there's really no leverage to make him do that, because you're already done with the project and he doesn't need you to show up to finish any work, so the best way to ensure that you're paid your retainage is file a lien when you're done or when the project's done. That way, when the owner does pay retainage, you can get paid from the owner, as opposed to waiting. Because I'm not saying all general contractors are this way, but I've seen in the
there's
past,
enough of them that are.
The general contractor's gotten paid by the owner and intentionally holds that money, and then goes around and negotiates with the subs. Hey, we haven't gotten paid yet, so I'll pay you 50% of that. And the contractor's not wanting to litigate and knowing the time value of money, just take it. But I mean, depending on what state you're in, retainage is generally 10% on general projects and 5% on public works. That's if you're making more than 10% margin on your jobs, you're doing awesome, right? Mm-hmm. So it's basically you're giving your profit away. You basically paid the general contractor to go to work.
Yeah, exactly. That's my point all the time. Is like, if you're making a 10% net on this job, your profit's in the retainage. So
yeah. So I agree. So you can even file a lien after you leave and just put in the lien that is for retainage. Don't get me wrong, that pisses everybody off, but it's very effective.
Yeah. Well, guess what? You did the work. We have a contract. You're supposed to pay me for that work.
Exactly. And I know technically under the contract it's not due till the project's complete, but it doesn't say I can't file. Most of them currently don't say I can't file lien before that time, right?
Yeah.
And that's the thing about liens. You can always file them early. You just can't file them late.
Got it. Yeah. You file them late, you lost it. It's done. It's over.
Yeah. Well, not only that, you could not only lose the amount that you're owed money for, but you could be penalized if because a lien will stop a sale or will stop financing. And if your lien's invalid and you stop one of those and it gets screwed up, you're on the hook for what the damages caused. So liens are great leverage, but they need to be taken seriously. And I have yet to see any of those online lien filing services do a lien properly.
Good. That's good to know.
Yeah.
All right. If somebody wants to contact you directly and not go through the website, how would they do that?
The CromeensLawFirm.com, or my email, which is Karalynn, which is KARALYNN at theCromeensLawFirm.com.
Cool. And the name of the book again?
Quit Getting Screwed, available on Amazon.
Very good. So get a copy of that book, and forewarned is forearmed. Karalynn, thank you so much for being with us today.
Thank you so much for having me.
And thank you to all of you for joining us. Choose one thing that you discovered and implement it in your business. These ideas, tactics, and strategies help you make more money, have more free time, and give back. If you like today's program, spread the word. Please review this podcast on any device you're listening to it on. Help a fellow contractor make more money, too. For comments or questions, call me at 770-729-0258 or email Ruth King at hvacchannel.tv. Thanks for listening. Have a great and profitable day.